1819, the candidate studies 11th and 12th from the state of Gujarat. All right. Now, in the 19 NEET, the candidate does not qualify. In 20 NEET, the candidate gets a very good score. Now, which state domicile or which state under the rules 85% quota would that candidate be entitled to?
Milord, therefore, this candidate, yes, Milord, this candidate who has undertaken, Milord, standard 12, 16, 17, Milord, from any university outside the state of Gujarat had two options. Milord, when we make choices...
What about the options which were there earlier? Now, once you frame a rule, you have to take care of these students also.
Milord, we take care... Milord, the state is responsible for taking care of... It's a question of balancing interest. The largest populace we take care of. Every and to the last single option, exception which may be carved out for any hardship, Milord, rules cannot be modified. My submission is, Milord, a student who makes a conscious choice, chooses to study outside the state for 16, 17, has the option of studying for the 11th and 12th outside. For reasons any and many, he may have chosen to come back to the state. In which case, Milord, he is required to face all the options which are then. All academic matters are a matter of choice.
Not just that. Now, test it on the other side. Earlier, there was no requirement of domicile. Now, domicile has also come into play.
Correct.
Correct.
Validity again upheld. Domicile was also challenged. Domicile was challenged. Hardship was the argument. There is no enforceable right in a student to say, I will study in my state alone. There is no enforceable right. When you make choices, when you take decisions, these are decisions coupled with an element of chance. Every decision taken is coupled with an element of chance. The reason he took an admission in quota for better prospects perhaps may have worked, may not have worked. The state cannot be getting into the mind of every child to examine the reasons and the objects for which, Milord, such decisions are taken. Every step taken is always for a betterment. Be that as it may, today, Milord, when the state is taking a policy decision, Milord, in my submission, we are bound by statute. What he's essentially saying...
What we are trying to... We are not conversing, Mr. Desai would be conversing. What we are trying to ask you, when you come up with the rule, you apply it from that date onwards.
Right.
You are ousting students from getting their 85% quota in the state, which they fulfill all conditions, including domicile 11th, 12th, but for something which they have already done and acted upon. You say, no, you are out. How far is that justifiable?
Yes. Milord, my lords, be pleased to see, while examining the vires, one argument, Milord, on behalf of the Advocate General submitted that last year itself, 400 students from, Milord, outside the state had taken admission. These are essentially the students who ultimately do not land up staying back in the state. They take the advantage, the benefits of the infrastructure, of the academic teachings which is being made available by the state. But the state does not manage to receive the benefits of these students who ultimately pass out. And all these numerical data, all the factual scenario, all of it was considered. Having considered it, the rules were upheld. However, the Honorable Court said, you may consider for this particular year, if you deem appropriate. That considered for 18, 19.
Why did you consider for 2 years? Why?
Milord, it was considered for 18, 19.
Why?
And thereafter it was considered for 19, 20.
Tell us why. What has changed today that you are not considering it this year and you considered it for 2 years?
The reason why it is not considered it, Milord, the reason for the third year.
So, why did you consider it for 18, 19 and 19, 20 and not...
Because a student, Milord, a student who has already completed the 10th, Milord, for that student, we are not able to do much. But here is a student who took admission in April. It was always open. Milord, the rule was notified.
And you do whatever you feel is proper. You have done it. Then why do you relax it?
A moment. Milord, a student, the rules were amended in June 2017. this student has taken admission in April. It is always open to the student to opt for the state
We
admission.
are not talking about this particular matter. We are asking you, why did you relax that for 2 years?
Considering that those students who may have already studied out may not be
You realize that there was
requirements.
some error in your rule and therefore you are doing it. You are taking hardship as a consideration.
My lord, it was only considered as a,
you are being fair.
my lord, so far as the present petitioner is concerned,
No,
my
we
lord,
are-
please to see this option was open to him. June, we amended the rules. A student who had taken admission in April may very well come back to the state. In June, he was aware that with 10th standard in quota, he would not be able to come back to state of Gujarat. It was always open for him to take admission in June. He chose to continue, my lord, in quota.
Then supposing you had brought out another rule in October saying that no, you were allowed to,
Lord, can that be?
and was not required. They could have gone back to this. How
No,
many
no,
times
no,
would
no,
they take admission in
Can that be the
academic year?
consideration of the honorable court? Would
Once
these
you take
factors weigh with the honorable court?
Once you bring out a rule, apply it prospectively and don't oust students who have already acted upon their previous existing rule and they are not violating any part of your rule.
My lord, my submission is that so far as 2017 rules are concerned, those who would have acted would have been in 2016. Those who would have acted would have been in 2015. Whereas in the facts of this
is what
case,
we've been saying that.
yes,
but
but in
taking
the facts
consideration
of
all
this
those
case,
aspects, why not this?
yes, because in the facts of this case, this student has taken admission in April. He very well could have changed his admission in June.
Ms. Shah, just come to page 111.
In June, my lord, he had the option. He had the knowledge and option.
How many times the Ghazis are going to pay the fees? Do you realize what is the fees of and how much is the cost of staying in a hostel and paying the entire year's fees? Nobody charges fees for months. And then getting a fresh admission in another school in midterm is so difficult.
My lord, there
How
may
is
be
the state
any
going to
and
help?
many such there may be any and many such hardships.
All right, you have no
It's
answer.
not a matter of policy.
Just because you are mighty and you are powerful, you can make any kind of rule and
No,
try
no,
to
it's not
justify
about
it.
mighty, it's
I
a
don't
question.
agree to that.
You know, the question
The
is,
state is not justified
the
anyway.
state is not inclined to open floodgates to those students who have studied outside. The virus is not a matter of
Anyway,
challenge
you
today.
take a decision and implement it from the next year. Who stops you from doing that? You have done it and successfully you are doing it. Nobody is stopping you. Maybe a
No,
state,
the virus today is
here and there
these rules.
who are in this kind of a situation would come. Not all. Yes.
Ms. Shah, come to page 111.
Please, my lords.
We are referring to para 34.
Please, my lords.
But you may skip around first part of para 34. The sentence starts like this. It is the case of some
I'll
of
read.
the petitioners.
It is the case
Just a
of
minute,
some of the
just-
petitioners
Just
that
a minute.
though they fulfill domicile,
1 minute. It is the case of some of the petitioners that though they fulfill the criteria of domicile and passing requirement of 12th standard from the school situated in Gujarat. So, twin requirements are fulfilled, domicile and 12th standard from the school situated in Gujarat. But they are excluded from the eligibility criteria only on the ground that they have studied 10th standard from the school outside state of Gujarat. Exactly the situation in the present litigation, correct?
please, my lords.
Now, just make us understand the ration, that the idea of such observations which we'll read now. In that view of the matter, as object of the rules, is to give benefit to the candidates who are domicile of the state of Gujarat. We just want to understand from you, is this candidate not a resident or a domicile of the state of Gujarat? We direct the respondent state to take decision forthwith on the said issue, whether to continue Rule 4.3 subclause II of the regulation so and so in the same form or not, and take appropriate decision accordingly without loss of. Now this gave rise to page 113 and 116, right?
That's right.
Now the object seems to be, the court observes, as object of the rules is to give benefit to the candidates who are domicile of the state of Gujarat. If you hold, if you believe that the domicile of this student is also of Gujarat, then why not give one benefit for this particular year?
My lord, I
That is
have
17, wait a minute, 18, 19,
1920
1920, 2021, and
Yes.
that's the end of it.